So when it comes to how the VA weighs buddy statement evidence, how does it compare to, service treatment records or other types of evidence?
Well, if you were going to put evidence on kind of a gradient, the VA is always happiest with military records for medical issues, service medical records, or scientific evidence that really is beyond dispute, that this is medically recognized, that A causes B kind of stuff. But as you sort of work down the chain, buddy statements I would put somewhere in the middle. The problem in many of these cases is that the VA just won't take the veteran's word, even sworn testimony sometimes, unless there's some kind of other support. And that's unfortunate, but many VA adjudicators come at this sort of the way an insurance adjuster does. The person who's going to benefit may not always be telling them exactly what happened. So they're always a little skeptical if there's nothing beyond the veteran's testimony to the VA to support the claim. And so it's always helpful to have some kind of support. It can vary from claim to claim, whether you're talking about related records from another source, or you're talking about medical opinions, or you're talking about buddy statements as we are here. But in every case, the more corroboration and support you can provide for the claim, the easier it is for VA to say, okay, we think you've proved this, and grant the benefits.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Welcome to Victory Over VA. If you're a veteran struggling with the VA's disability system or just want to make sure you're getting the benefits you've earned, you're in the right place. Don't forget to hit subscribe so you never miss an update that could change your life. I'm Kristian Terison, here with renowned veterans disability attorney Francis Jackson of Jackson and MacNichol. Jack has dedicated his career to helping veterans like you win the benefits you deserve, recovering millions of dollars for thousands of heroes. This podcast isn't just for veterans navigating the system, though. It's for their families, their friends, and anyone else who wants to stand shoulder to shoulder with those who've served. So stick around, because we're here to make sure you get the support you need. Now, today's episode is on the topic of buddy statements. Now, they're actually one of my favorite parts of working up a case when they're applicable. But can you, describe a little bit what are buddy statements in the context of VA disability?
Buddy statements are just VA slang for a statement by typically someone who served with the veteran, but it can also be a statement from a friend or relative who has factual information that's important in relation to the case.
Okay. And why, does the VA allow these type of statements into evidence?
Well, it allows them into evidence because VA recognizes that not everything is going to show up in some kind of formal record maintained by the military or the VA, and they have to have a method for getting other information about the claim. And most typically, these are just informal statements from someone who has factual information that bears on the claim.
Okay. Can you talk a little bit about why a buddy statement can be powerful in a case where there's an incomplete record, something's missing?
Sure. The thing you have to remember is these statements that we're calling buddy statements can be about an almost infinite range of information. So say, for example, that you have a case where there's an assertion by the VA that there's been no showing of an incident in service that could trigger PTSD. And as you know, to get service connection for PTSD, there is a requirement that you show what they call an in-service stressor, typically some kind of life-threatening event, either to the veteran or to someone else that the veteran witnesses. So, for example, we had a case, well, it's been a few years now, but the veteran explained that his PTSD rose out of an incident where he saw I think it was a helicopter, it might have been a small plane, but I'm pretty sure it was a helicopter, crash at the site where he was stationed, and they had to pull the bodies out and all that unpleasant stuff. And the VA said, nice, theory, but you haven't shown us factually that this happened. So what he was able to do was to give us the name of his commanding officer, and we tracked the commanding officer down in Labrador and got a statement saying that, in fact, this gentleman had been in service at this base, and they'd had this emergency where, I've forgotten, if I remember right, the helicopter was caught in a storm and was off course, but anyway, it ended up at their particular location where it wasn't supposed to be and crashed, and people were killed. So because it wasn't supposed to be there, the military had a hard time finding the correct records. But we were able to get the statement from the former commanding officer, and we won the case.
So when it comes to how the VA weighs buddy statement evidence, how does it compare to service treatment records or other types of evidence?
Well, if you were going to put evidence on kind of a gradient, the VA is always happiest with military records for medical issues, service medical records, or scientific evidence that really is beyond dispute, that this is medically recognized that A causes B kind of stuff. But as you sort of work down the chain, buddy statements I would put somewhere in the middle. The problem in many of these cases is that the VA just won't take the veteran's word, even sworn testimony sometimes, unless there's some kind of other support. And that's unfortunate, but many VA adjudicators come at this sort of the way an insurance adjuster does. The person who's going to benefit may not always be telling them exactly what happened. So they're always a little skeptical if there's nothing beyond the veteran's testimony to the VA to support the claim. And so it's always helpful to have some kind of support. It can vary from claim to claim, whether you're talking about related records from another source, or you're talking about medical opinions, or you're talking about buddy statements as we are here. But in every case, the more corroboration and support you can provide for the claim, the easier it is for VA to say, okay, we think you've proved this, and grant the benefits.
Now, you mentioned stressor verification for PTSD claims. Are there other types of claims that especially benefit from buddy statements?
Well, almost any claim can benefit from a buddy statement. Take sleep apnea, for example. We've had some sleep apnea cases where we were able to get statements from people who were in basic training with the veteran and remembered that they had to move his bunk over near the door because he snored so loudly. That sort of thing. I mean, there's an infinite variety of things you can prove with buddy statements.
I remember one buddy statement in a sleep apnea case where the buddy wrote, "We used to call him the train because he snored so loud." That one's going to stick with you.
You'll never forget that one, yeah. But that's my point. I mean, really it can be about almost any kind of factual information that is helpful to support the claim. The thing about buddy statements is that they're not restricted to statements from buddies in the service. That's just a tag that the VA in their internal parlance has kind of put on these statements, but they can be really from anything. For example, in one case we had a statement from the veteran's wife saying they'd gotten married just before service and he was fine and he went in the service, and by the time his service hitch was up, he was complaining about his back and continued to complain about his back right up until the day we were she was making this statement. And, he explained that he'd heard it in the service, and the VA said, well, that's all very nice, but there aren't any records. And she said, he's been complaining about his doggone back ever since he got back from the service. If he picks up something heavy, he grunts and groans and says it hurts, and we ultimately won the claim.
I wanted to ask a little bit about how to make an effective buddy statement. What are some of the things that the VA is looking for when they're looking at how believable or how powerful a buddy statement is?
Well, I think there are really two things. One is you have to explain in the buddy statement how the person making the statement would have information about the issue. In the example I was talking about before, the commander was obviously on the scene and, was actually in charge of the attempts to get the bodies out of the wreckage and so on. So he had obvious personal knowledge of what happened. And it's the same kind of thing. The statement about your example with the train, people were there and, remembered. So you have to start in any one of these statements by explaining how the person who's making the statement would have information about the issue. So that's the first piece. The second piece that goes into making it more credible or believable, however you want to phrase that, is detail. The more detail you can provide, the more credible it is. If you say, oh, I saw Jones fall and hurt his back, that's fine. But if you say, I was on guard duty and at, this location and we'd had a freeze, there was ice, I saw Jones come out of the barracks, slip on the ice, and after he fell, he lay there for a while, he was groaning, he had a hard time getting up. The more detail you can put into it, the easier it is for the VA to say, gee, if this person knows that much detail about it, that probably is correct.
Gotcha. So erring on the side of telling the full story, giving the narrative instead of just a naked statement of facts is going to be more compelling?
Always. The more detail you can provide, the easier it is for a VA adjudicator to say, okay, that makes sense.
Gotcha. And then on the flip side, are there mistakes that you've seen in buddy statements that make them less effective or even, in extreme cases, potentially hurt a case?
Yeah. One of the things that I think you have to be really careful about is when you're doing buddy statements about things that happened 20, 30, 40 years ago, there are two things you have to pay attention to. One is people misremembering dates. That is one that I've seen on more than one occasion, and it can be a real problem. The VA is looking at this and saying, now wait a minute, Jones says this happened in 1976, and Veteran Smith is saying it happened in 1974. I don't think these guys are talking about the same thing. That's one kind of problem. The other kind of problem that you run into sometimes is people trying to convey sort of secondhand and third-hand information, saying, well, such and such happened, but when you actually talk to that person and kind of drill down, they say, well, I didn't see it, but Jones, told me that Smith saw that, So you have to be a little careful about how you lay out exactly what happened and make sure that you lay it out in an accurate way. Sometimes when people describe things without a lot of detail, you come away with a misimpression that can actually be at odds with what happened, and it may come out that it's at odds with what happened.
I'll never forget another case I was working on where we had a fellow who had a buddy, an actual buddy who he kept in contact with after service, and they were real close, but who hadn't witnessed the event personally. And then there was another fellow who I think they were friends on Facebook, but they didn't get along in service. They weren't real close, but he was the one person who was there when this injury happened. And he didn't want to talk to this guy. Oh, he always gives me an earful, etc., etc. He ended up, after I looked at the buddy statement from the buddy and saw that it wasn't going to be particularly effective because this buddy hadn't seen the injury, the veteran's wife went out, talked to the fellow who had witnessed it, who didn't get along with the veteran, and he ended up writing a great buddy statement and enclosing a note saying, I don't like this guy, but I don't like the VA more. And, and I thought, you never know till you ask.
Yep, we've had some kind of odd ones.
Yeah, it's what makes it one of my favorite aspects of the case, because it really does bring in a lot of the human dimension to what can be, especially from the VA's standpoint, a cut and dried inquiry.
Yep.
Yeah, but let's see. Can you have an instance where you would have a claim that would benefit from multiple buddy statements that sort of work together to paint the factual picture, or should that be avoided?
Oh, no. More is better in many instances. So we had a veteran. In fact, we still represent him many years down the road. We're trying to finish up getting his benefits back to the earliest possible date, although he's already at 100% right now. But in his situation, the kind of central event that he based his claim on initially was he was in the club at the base and got in a confrontation with the MPs and got beaten really badly. I mean, seriously injured. Not entirely without some cause, apparently. But in any event, what we ended up with in that case was a series of events where he actually had several different events before this incident with the MPs, and we were able to show that he actually had an ongoing mental health problem. The reason that was important, as you know, but some of our viewers may not, there is a provision in the law that says that if you are the cause of the problem, then you may not be entitled to service connection. It's called willful misconduct. So the argument that the VA was making in denying this particular gentleman's claim was that his confrontation with the MPs arose out of excessive drinking on his part and didn't really have anything to do with mental health. He was just drunk and disorderly, and the MPs were trying to do their proper job and restrain him and so on and so forth. The point of all this was that by getting statements showing that things had happened prior to this, we were able to demonstrate that this was really an ongoing mental health problem and not a one-time willful misconduct problem.
Did that veteran happen to start their term of service on a high note and was a real top performer until the mental health issues? Because I may have worked on that one as well. It was one with a similar fact pattern.
A similar fact pattern wouldn't surprise me. We've seen some of these, but I don't remember that his evaluations were okay, but I don't remember that they were outstanding.
Okay. In any event, unfortunately, that's all the time we have for today's episode. But thank you for watching, and please be sure to like and subscribe and join us again next week.
We hope we'll see you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.